Welcome to the next in our series of FOIL podcasts from the product liability team at FOIL. I'm going to be talking about vaccine compensation schemes and asking the question, will these help the global COVID vaccine rollout? So this is the next in a series of podcasts given by the FOIL Product Liability Sector Focus Team. I hope you enjoyed watching the last talk from Daniel West of BLM on claims under Section 41 of the Consumer Protection Act. As I mentioned, my name is Joanna Fulton. I'm a partner at Burness Paull, a Scottish-based commercial law firm. So I'm going to be talking about vaccine compensation schemes. Even a swift glance at the latest statistics demonstrates the stark differences in the pace of the COVID vaccine rollout across the globe. Inevitably, these disparities raise questions about why it has taken some countries longer to roll out their vaccination program than others. Well-publicized procurement issues and supply delays are one part of the picture. Another seems to be a lack of trust, whether this is with the COVID vaccine itself or as part of a broader anti-vax movement. And with the Queen in the UK commenting on this issue a few weeks ago, these concerns are clearly being taken very seriously and will no doubt only be exacerbated by the incidence of blood clotting relating to the AstraZeneca Oxford vaccine and more recently the Johnson & Johnson or Janssen vaccine. Part of the solution to these issues, which is recognised as a critical pillar of any vaccine rollout, is the existence of a no-fault compensation scheme. And this is a stark recognition that sadly, as with all vaccines, it is likely that some people will experience a serious adverse reaction. So looking first at the UK scheme, the question that is being asked is it fit for purpose? Broadly, the purpose of such schemes is to assess claims by individuals who have experienced serious adverse impairment as a result of a vaccine and, where proven, to administer payment of a sum to them in recognition. A well-established but much criticised scheme exists in the UK. This was created by the Vaccine Damages Act 1979 and was established as a result of concerns over adverse events related to the diphtheria, tetanus, pertussis vaccine. Critics point to the fact that since its inception, only 941 claims out of 6,352 applications have been successful. The vast majority of claims are turned down on the basis that it has not been proven that the vaccine caused the claimed disability on the balance of probability. The upper limit of £120,000 for an award is also regarded as too low in light of the severe disablement that qualifies for an award. An applicant needs to be at least 60% disabled as a result of having the vaccine. Commentators say a new bespoke scheme for COVID-related events should be established in the UK. Not only should this allow compensation based on need rather than a fixed sum, it should facilitate the process for proving causation and be more simple, swift, and transparent. So, a new international approach. The UK scheme sits in a complex puzzle of other no-fault compensation schemes across the globe. The newest of these, and notable for its scale and ambition, is the compensation scheme linked to the COVAX facility, which is the international scheme led by the WHO to ensure everyone in the world has access to a COVID vaccine. It is the first and only international vaccine compensation scheme of its kind and is open to individuals in 92 low and middle income countries who have received a vaccine through the COVAX facility. There are a number of reported motivations for such a scheme, including a desire to provide reassurance to the public to encourage take-up, but also as an alternative to complex indemnity and liability arrangements, apparently requested by some manufacturers. So, the COVAX programme reflects the common elements of many such schemes. The programme itself is available as of the end of March, and the programme documents reflect a number of similar elements that are common to all such schemes. Firstly, it contains rules on administration and funding. The programme is financed through donor funding calculated as a levy charged on each dose of vaccine distributed through the COVAX facility in eligible countries. The programme is being administered by Chubb's subsidiary ESIS, and the WHO is working with Chubb to secure insurance coverage for the programme. Secondly, eligibility criteria. The programme covers serious bodily injury or illness, so non-serious events are not covered. Thirdly, it contains elements of due process and decision-making. The injury is assessed by a review panel of 5 licensed nurses. Next, it has a required standard of proof. The injury must be shown as the most probable cause of taking the vaccine on the balance of probabilities. Next, there are certain elements of the compensation award. In the case of the COVAX programme, the amount of any payment is based on the GDP per capita of the country in which the claimant lives, times by a multiple of 12, and then by a harm factor based on the degree of disability suffered. Contrast this with the one-off lump sum under the UK scheme. And lastly, litigation rights. A claimant will be asked to sign a release agreement noting that no admission or fault should be construed from the payment, and they will not be able to pursue compensation through the courts if they accept payment from the programme. Again, contrast this with the UK scheme, which does not prevent claimants from pursuing a court claim to top up the award. So inevitably similar issues are likely to arise as with the UK scheme, such as the degree of injury required to obtain a payment and the need to establish the vaccine as the most probable cause. However, before these elements of the programme even come into play, there is perhaps a more fundamental issue given the difficulties inherent in promoting and accessing such a scheme in these type of low and middle income countries. At its most basic, individuals will need to know of such a scheme in order to seek a payment. Accessing the programme requires online access to obtain forms and understand the requirements, although there is a free global telephone hotline to assist. Filling out the relevant paperwork and providing supporting evidence will not be an easy task. The launch of the programme will hopefully be accompanied by information campaigns to extend its reach as far as possible. Criticism on some of these issues have also been made of the UK scheme, which is not well publicised and whose processes have been criticised for lack of transparency. And this is in a country with a high level of internet access, literacy and support services. Nevertheless, in conclusion, the promoters of the programme have to be applauded for their ambition and determination in getting this off the ground. With nations becoming seemingly more insular, both at political level with global disputes over rollout and supply of the vaccine, and at a private level as people are confined to narrow city and regional borders, any initiative to increase vaccine uptake is to be welcomed if that propels us forward to a more open future. Many thanks for listening to this podcast. The next talk in our series is from Nicola Fallowfield-Smith of Hawkins, who will discuss user fault versus product fault. And she's going to be looking at what assistance can forensics provide to your product liability case, some of the typical causes of product faults, and steps you can take to ensure useful results from a forensic investigation. Thanks again.